My name is Courtney Baker, and I work for the Associated General Contractors of Virginia. Today, our webinar is going to be on post-COVID planning, PPP loans, audits and investigations, mitigation strategies to protect against bankruptcy and collections. Today, we're joined by three experts from Miles and Stockbridge to talk on the matter. Miles and Stockbridge is a leading law firm with offices throughout the Mid-Atlantic region. The firm's more than 220 lawyers help global, national, local, and emerging business clients preserve and create value by helping them solve their most challenging problems. Its construction industry team represents general contractors, subcontractors, owners, suppliers, and sureties in all aspects of construction law, including contract drafting and negotiation, mechanics liens, bid protests, and litigation, arbitration, and mediation of construction claims. Before I introduce you to our panelists, I do have a few features on the webinar for you to be aware of. Everyone is going to be muted throughout the duration of the webinar with the exception of our panelists. However, we do encourage you to send comments and questions using the Q&A button down at the bottom of your webinar screen. You'll see a little toolbar that says Q&A. You can type your questions and comments there. And then throughout the course of the webinar, certainly by the end, we'll be sure to address all those questions. Today we are joined by Holly Drumheller-Butler, Jack Robb, and John Farnham. So Holly counsels domestic and international companies in commercial litigation, government and internal investigations, and corporate compliance. Her practice ranges from handling bet the company class action matters to traditional commercial disputes. Holly has significant trial experience, having tried cases in various federal and state courts. She also has conducted investigations in a broad array of sectors and has represented companies in investigations by the Department of Justice, Office of Inspector General, regulators, and enforcement officials. We're also joined today by Jack Robb, who is a construction attorney who has helped contractors and owners litigate and resolve claims for nearly 15 years. He's a former in-house general counsel and regularly advises clients on contracts and other business matters. He has authored numerous publications in the construction industry and has been recognized by Virginia Business Magazine as one of Virginia's legal elite and Law and Politics Magazine as a Virginia super lawyer. Third, we are joined by John Farnham. He is a bankruptcy attorney and commercial litigator. His practice focuses on financial restructuring matters, insolvency law, distressed transactions, and out-of-court workouts. He has experience representing Chapter 11 debtors, bankruptcy trustees, creditors, and other in bankruptcy cases. He represents clients in state and federal courts throughout the Mid-Atlantic. He is an immediate past president and a member of the board of directors of the Northern Virginia Bankruptcy Bar Association. He also serves as co-chair of the American Bankruptcy Institute's Secured Credit Committee. Prior to joining Miles and Stockbridge, John served as a law clerk to the Honorable Ross W. Crum of the United States Bankruptcy Court in the Western District of Virginia. So if you guys have any questions throughout there, again, I encourage you to ask. I think it's going to be a really good webinar. It is the third in a series of 3 that we've held. So if this is the first one that you all are able to attend and you're interested in seeing the other 2, just let us know and we'll be sure to get you those recordings. But for the sake of time, I'm going to go ahead and turn it over to our panelists.
Thank you, Courtney. This is Jack Robb. Sheila, can we please advance to the next slide? Thank you everybody for joining us today. Like Courtney said, this is part 3 of our webinar series, Post-COVID Planning. In part 1, we covered practical strategies for restarting the job. And we heard from some of the firm's employment lawyers and construction lawyers about specifics for PPE on construction sites. Part 2, we covered a new Virginia statute related to wage theft. And then in this part 3, and Sheila, would you be willing to advance to the next slide, please? We're going to cover planning for a potential PPP loan audit or investigation. We're going to cover 5 practical tips for collections. And then John's going to talk about mitigation strategies to protect against bankruptcy. We're going to go over a few hypotheticals, and the panel's going to talk about how project manager or CFO can handle challenges in those topics, and then we're going to leave plenty of time for Q&A at the end of the presentation. So I'll turn it over to you, Holly. And Sheila, I think we're on slide 3 now.
Good morning, everyone. Sheila, could you pop ahead to those slides, please? That would be helpful. We wanted to start with a little bit of context this morning. So, as you all know, the PPP loans represented a significant lifeline for the construction sector. In the first round of the PPP loans, the construction companies had the largest share of these loans, and that accounted for approximately $45 billion. Now, as a result, the construction company is also one of the sectors hit hardest by the uncertainties surrounding the program's interpretations, as well as the risks of future government investigations. So hopefully today's webinar will alleviate some of that confusion and provide you with some practical advice on mitigating your risk going forward. Courtney, are we able to move to the next few slides so that everyone can keep up with the points?
Yeah, I just reached out to Sheila to see if she was having issues, so I'm going to pull it up on my end and get that up for y'all.
Awesome, thank you so much.
Of course.
So I'll try and do a little bit of instruction, more than just the talking points, so you guys can imagine what the slides would be like. They're just simply beautiful, you can expect. So let's start with a quick review of the representations and certifications that were contained in the PPP loan application. That'll provide the structure for our discussion with regard to risks, review, and so if you personally or your company sought a loan through the program, a representative of the company certified face a number of representations and certifications. Some of the representations were relating to civil rights and use of American products. If we could fast forward to, I believe it's slide 4 now, that'd be helpful. With regard to those representations, the application caveated the obligations with phrases like wherever applicable or to the extent feasible. That vagueness, as opposed to a clear directive in a certification, will make subsequent enforcement more difficult for the government. So the focus for our standpoint is on the more concrete, as I put that in air quotes, certifications, because there's been a lot of confusion and fuzziness around this program and the certifications. For purposes today, we're going to look at certifications regarding to eligibility, use, need, and the supporting documentation. So I believe if we could pop to slide 7, we're looking at the needs certification. And if we can't pull that up, I'll fill you in on what that is if you're not familiar with it. So the needs certification stated, quote, current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. So that particular certification has received a lot of attention from the Small Business Administration and the Department of Treasury, the two that are in charge of this PPP loan program. And if you were following the news in April, you're aware of the public outcry that stemmed from news reports of large companies who were accessing the limited pool of PPP funds. These companies were qualified under the program as written, but they faced a heightened level of scrutiny from the public, from the media, as a result of the actual or assumed access to alternative funding. Wonderful. If we could go to the next slide, please. So the loan program was rolled out quickly in response to COVID-19 pandemic, and there was little to no guidance on the program. Subsequent guidance and interim rules have not been clear. They've not been consistent. In some cases, they've changed the underlying law, and they've caused sometimes more confusion and concern for the applicants. So let's try and provide a little clarification, and then we'll move forward to the remaining risks. We could go to the next slide, 9. That would be helpful. Thank you. So a great deal of concern was caused when the SBA, the Small Business Administration, issued a series of FAQs. Particularly FAQ 31 caused a great deal of concern to the applicants because it warned borrowers to carefully consider their needs certification and actually suggested that those with alternative sources of liquidity could not make that certification in good faith. So the reason for the confusion, just to give a little bit of background, is that there was express language in the CARES Act that suspended what's called the credit elsewhere requirement for the SBA loans. So generally that requires lenders to certify to the SBA that a traditional borrower under a 7A program cannot obtain comparable credit elsewhere. So this guidance in FAQ 31 seemed to suggest that for certain borrowers, some alternative test or self-certification were required. So this FAQ provided what we refer to as a safe harbor, and it's safe harbor number 1. Spoiler alert, there's 2 of them, so we'll get to the next one in a second. So this safe harbor allowed borrowers to reevaluate their needs certification. And if they felt that they were going to have this issue with alternative credit, they could return the loan proceeds. Originally, the deadline was May 7th. That was extended to May 18th. And if the money was returned, there was no risk of any type of bad faith determination on that needs certification. And if we fast forward to the next slide and jump ahead in time to May 13th, 2020, the SBA issued another set of FAQs, and FAQ 46 provided another safe harbor. So this safe harbor divided the loan recipients basically into 2 buckets. There's the group of people who received loans for less than $2 million, and those who received loans at or above that amount. So those with loans of under $2 million, the SBA said, we're going to deem those applicants to have made the certification of need in good faith. However, with regard to those who received $2 million or more, we are going to evaluate those need certifications. And if it was made without an adequate basis, not in good faith, then we're going to ask the applicant to repay the balance of the loan, and they will not be eligible for forgiveness. The perk of this FAQ 46 was that the SBA said we will not refer these improper needs certifications to the DOJ for criminal or civil prosecution. So before you breathe too much a sigh of relief about the safe harbors, understand that there are very definite limitations on them. And if we could jump to the next slide, please. So safe harbors do not provide full immunity. They are not absolute. And there's 3 areas that I want to highlight where there remains some potential exposure. So safe harbors, 1, revert only to the need certification. They do not provide protection with respect to any other fraudulent conduct in the PPP loan process. So what does that include? That could be false certifications regarding your eligibility requirement, false certifications regarding your period of the company's operation or the number of your employees. And it could be improper use of the loan proceeds. So the need certification safe harbor is somewhat narrow in its scope. Next slide, please. So number two, where it doesn't provide immunity, is the DOJ, the Department of Justice, has a wide reach. So the SBA may not refer an action. The DOJ can still initiate civil or criminal actions against a PPP loan borrower, even where there's no referral. It may alter the likelihood of that happening in the equation, but it's still an option for the DOJ. And of course, with regard to whistleblowers, none of the safe harbors prevent a whistleblower from filing a suit. So next slide, please. So make no mistake about it, this is a priority for the Department of Justice. They are keen to draw back any loan proceeds that were obtained based on fraud. You cannot review any press release on any of their actions without the assistant AG from the criminal division offering a quote about how they will remain vigilant and how they are poised to do just that. So let's go to the next slide, please. So in fact, the government has dedicated a number of oversight and enforcement mechanisms to this program. We have the Pandemic Response Accountability Committee, which they're referring to as PRAC. Gotta love the acronyms. And that has 20 inspector generals. And with the addition of Inspector General, the Special Inspector General for Pandemic Recovery, who was approved last week, Brian Miller, there's 21 members of that PRAC. Beyond that, of course, we referred to the DOJ, who is poised to act. There are also U.S. attorneys' offices in each of the individual states who are looking into these programs and the recipients. And of course, Inspector General's offices for the governmental agencies. Layer that with state regulators who will be looking at their own False Claims Act provisions, as well as a layer of congressional committees who no doubt will be having hearings on this for the foreseeable future, and my children will probably study it in college. So let's move to the next slide, please. So we know the PPP loans are going to be an area of interest for the government. What are the risks here? If you've reviewed the application or signed yourself, you're probably familiar with the 4 risks that are identified on this slide. These 4 risks were enumerated expressly in the application. So let's just chat about what they are. So, if you could go back, please. So, I believe it's team, there we go. So false statements, 1001. This is kind of the low-hanging fruit, easy access potential for criminal liability. This is simply making a false statement to the federal government. It can be in writing, it can be oral. There's no obligation for an oath. This is a frequently used statute for the government in order to prosecute people who make any type of false statement in connection with the government. 3571 for sentence of a fine. That's really a complementary statute. With 1001, it increases the fines that are available to the government. Aid to small businesses, that's misrepresentation relating to the program for aid. And the 10,014 is self-explanatory. That's false statements in loan and credit applications, of which this is. So let's look at, nope, not yet. Let's look at the, talk about the what kinds of fines and prison time are available to the government under each of these statutes. So if you look at 1001 and 3571, you have a prison option of not more than 5 years and a fine of up to $250,000. Under 645, aid to small businesses, that is a prison of not more than 2 years and a fine of not more than $5,000. And then with 1014, if submitted to a federally insured institution, this is a big bell ringer. You've got imprisonment of not more than 30 years and a fine of not more than $1 million. So if you haven't looked ahead to the forgiveness application, forgiveness loan form, these same statutes are reiterated in that form. So this is going to be a definite focus in the context of government reviews going forward. Next slide, please. So beyond those enumerated in the application, you have past government relief programs that we can look to, and current activity by the government, which will show where the government intends to use these statutes. So beyond those in the application, these are the statutes and areas that the government will lean on. The False Claims Act, which could be a presentation of its own. The Program Fraud Civil Remedies Act, which is known as the Mini False Claims Act. And then we skip ahead to the last two. So in addition to civil and criminal risk, if you're a government contractor, you're painfully aware of the additional burden that there is a risk of suspension and debarment, even if there's allegations of misrepresentation. And of course, there remains the backdrop of public relations implications. The calculus on that last bullet changed a bit yesterday. So this is a continuing work in progress, and we are learning more about how the government intends to review and evaluate this program on a daily basis. Yesterday, the Secretary of the Department of Treasury, Mnuchin, spoke in front of the Senate and indicated that the government had no intention of releasing the names of the recipients of the PPP loans. That still remains up for debate as to whether that'll stick, but that may alter the calculation on that public relations implication going forward. Next slide, please. So on May 5th, the Department of Justice announced its first criminal charges related to the PPP. And this one was in Rhode Island. We had two businessmen who filed fraudulent loan applications seeking $500,000 in PPP loans. They misrepresented the number of employees, saying they had a few dozen when in fact they had 0. And they didn't even have an operating entity when the pandemic began. So you can see there the wide scope of charges that the DOJ brought against these individuals. Next slide, please. So I didn't outline each of these, both for time as well as the fact that I could never have a current enough PowerPoint with regard to the DOJ charges that are being brought on an almost regular daily basis. So recently, the DOJ has filed charges in 7 additional cases accusing defendants of fraud in connection with the loan program. So far, these are only the most egregious cases, going after the easy ones based on clear misreps in the application process. And rather than talking through the different cases and charges, let's just talk about the categories that these fall under. So far the DOJ is attacking individuals who submitted false payroll records on one hand, or diversion of loan proceeds, and sometimes a combination of both. So the false payroll records, with regard to the application, you have to submit who the number of employees that you have. Some people, in all likelihood, made minor errors and there were minor discrepancies. So far in these cases, the overstatements are particularly egregious. So they are indicating, the applicants are implicating at this stage that they had dozens, 200, or even 400 employees when they in fact had 0. With regard to the diversion of proceeds, the government is very keen on emphasizing that these loans are meant to save your business and not your lifestyle. So I'll give you one colorful example very quickly. And if you are familiar with this individual that I'm going to discuss, then you are probably far younger and far cooler than I am. The DOJ brought charges last month against a radio and TV personality by the name of Maurice Fain. He is a star of VH1's TV reality show, Love and Hip Hop Atlanta. So Mr. Fain allegedly received over $2 million in PPP loans. They were supposed to be used to help his trucking company, which does exist. But instead, he diverted those funds and bought a Rolex, a 5.73 carat diamond ring, other jewelry, a Rolls Royce, and even used about 40 grand of it to pay child support. So Mr. Fain's attorney was quick to comment and said, let me read this. He says that there has been considerable confusion among small business owners about PPP guidelines, particularly around the question of whether and how business owners are permitted to pay themselves a salary or take an owner's loss. So you can anticipate that with every investigation and every set of charges, there will be a confusion defense because of all of these changes. So next slide, please. Last one before we move on to you get to hearing someone else's voice. So this is really what you do now. How can you prepare in light of the inevitable reviews by the government and the investigations that will be forthcoming? And how do you put your company in the best position to respond? So recognize that time will pass and memories will fade before any potential SBA review or government investigation will take place. Most of the SBA reviews will be in connection with you seeking forgiveness of the loans, so that will be some time out into the future. And you need to look forward and put yourself proactively with documentation and actions that I've outlined here. So you're going to anticipate scrutiny. You want to maintain certain documentation that you've already submitted. Any of that should be maintained, and any of your certifications that have been made, you should document the basis for them now. Moving forward, you want to closely track your expenditures, and you want to keep a careful eye with regard to employee complaints, which should come back as whistleblower complaints to the government directly or in their own qui tam relator suit. Any complaints regarding receipt and use of fund proceeds are ripe for a False Claims Act litigation by a whistleblower. So with that expedited and speedy review of the PPP loan process and the risk going forward from a government, I'll turn that over, I believe, to Jack.
Thanks, Holly. That was great. We're gonna, AGC is gonna circulate the PowerPoint presentation to the attendees today, so everyone can have additional time to study the recommendation slide especially. So Sheila, could we please move to the next slide? So as part of our post-COVID planning, in addition to the PPP loan process and audit and investigation process that Holly covered, as John and I and our partners look to the fall and the end of the year, we're beginning to see and continue to anticipate financial challenges, particularly in the construction industry. So I thought it helpful to very quickly review 5 practical tips for collections that I use in my practice and counsel my clients. So Sheila, could we turn to the next slide, please? And when we talk about collections, I really put it into 2 buckets. So you're either collecting money for work you have done. If you're the general contractor, that's your pay applications from owners who are having cash challenges or lending problems. And then you're also thinking about collecting money from people who made you promises but did not keep them. Typically a supplier or a subcontractor that you have under contract, because of the choppy waters created by the financial stress, is unable to meet those promises. Sheila, next slide, please. Thank you. So tip number one, and these tips are really practical, specific tips. Do not overpay percent complete to subcontractors. If you're a CFO or a project manager for a construction company, you are looking for leakage on your construction project. We are in a recession, and in a recession, you must guard your cash to make sure that you can meet your obligations. So we already see this happening. Subcontractors could create positive cash flow on a project by billing or requesting payment for more percent complete than was actually performed, trying to get advances of cash for the purchase of materials. Take a hard look at each pay application. You know, if the pay applications are significant, have in-house or third-party inspectors. Banks do this all the time. Take a look at the percent complete. You know, make sure that when you pay a pay application that you have confidence that the work has been performed and that the money that you're paying to the subcontractor is going to be used to satisfy the subcontractor's obligations and not be money that the subcontractor will use for other things, resulting in lower tier subs and suppliers coming back to you and asking for payment. Understand that in Virginia, and this is a challenge for a lot of our clients, if a pay application is misrepresented, it's a breach of contract action. Virginia courts have been clear that because the submission of a pay application is part of the contractual obligation, there's no independent cause of action for fraud associated with that misrepresentation in Virginia right now. So your remedies are somewhat limited if you find yourself in this challenging circumstance. So tip one, take a look at those pay applications, and if you're going to let cash go out the door, be very confident that the work has been completed. Courtney, next slide, please. Tip two, know when and how to amend your contractual claim requirements. There are lots of articles and webinars right now about delay caused by the pandemic and the slow restart to the job. The number one way in which your business could be impacted, I think, in a negative way is by waiving your payment rights to claim delay by failing to comply with specific requirements in the contract to give notice of an event within a specific time period, right? Most contracts require detailed notice within X days of the events giving rise to the delay. It's a challenge when the event giving rise to the claim is ongoing. It's a challenge when the impact of the event is not known. So you can exchange emails and create flexibility with your counterpart, at the owner or construction manager to create flexibility in those contractual claim requirements. So let me show you an example. Courtney, can we go to the next slide, please? Emails are great ways in order to create a record so that down the road, when you have all the information and you do submit a formal claim, the contractor or the owner can't come back to you and say, look, you needed to have let me know about that, so we're going to deny your claim on that basis. And here's a simple email that I think would give you a great argument down the road that you haven't waived any claims. And what the email attempts to do is to formalize a conversation between you and your counterpart at the owner to create some flexibility. So the email is in the PowerPoint, and we'll send that around. But using emails like this can create that record, and that is something that you need to do now. It's uncomfortable to do it, but if you phrase it in a way that makes clear you're just trying to paper the file and you want to get the job done and want to have a clear understanding, my experience is that owners and others appreciate this kind of clarity rather than leaving things uncertain and then down the road it's a little different than what you thought it was going to be. Courtney, next slide. Tip three, tell the debtor, the person who owes you money, what you will do and then do it. One of the biggest mistakes you can make in a collection challenge that is starting to heat up and get out of control is to make an empty threat. Because if you say, you know, if I don't hear from you, I'm going to involve my attorney within 10 days. 10 days goes by and the debtor does not hear from you and does not hear from the attorney. You've lost all credibility in the negotiation for a resolution. So I typically encourage clients to, you know, ramp up a collections pressure steadily and demonstrate seriousness. Tell them exactly what you're going to do and then do it. And if you do that 2 or 3 times in a row as the pressure ramps up, then I think you'll have a better chance of a frank conversation with the person that owes you money and the ability to get a workout before you have to get a lawyer involved. Courtney, next slide, please. So tip 4 is to involve a lawyer at the right time. And whether that's in-house counsel at your company or that's an outside lawyer that you have a relationship with, you've got to make the right decision to involve the lawyer at the right time. So here's 4 things to think about, you know, when it's helpful. So if you need to get the other side's attention, oftentimes people in financial stress stop communicating because they don't have good answers. And, you know, we're all people and nobody wants to have conversations when, you know, they can't meet their obligations. So if you have to get the other side's attention, if they stop communicating, you cannot wait. And sometimes having a lawyer involved to reach out to the other side will be effective in getting their attention. If the other side is stalling, we see it all the time. They're not ignoring you, but they're participating in the conversation. They're providing information about their business, but there's no meaningful promise that they can make. There's no clarity in what a workout looks like, and they're stalling. The third thing to think about is if you want the other side to get a lawyer, that could be counterintuitive sometimes, but our experience is that if the other side has a lawyer, then now you've got an advocate that you can work with to try to get a cost-effective and quick workout of your collection. You know, the other side getting a lawyer gives the other side confidence that they're going to get a good deal, and it helps you and us document the deal in a way that makes sense. And then finally, you know, if you want to hire somebody else to complete the work, right, this could be dangerous if you have not followed the correct requirements of the contract related to notice of default and cure. But instead, you know, you just get somebody else to go in there and to complete the work. That you could waive rights doing that. So if you want to get somebody else, you know, that's the time when it makes sense to contact a lawyer. And when you do, most often, what the lawyer would recommend. Courtney, could we go back just one time? Yeah, sorry, we're still on tip 4. Prepare for the lawyer letter. So send to the lawyer the contract, some of the key correspondence. Prepare an attachment to the letter that's a breakdown. Lawyers are notoriously bad at math. So I always ask the CFOs of construction companies to calculate the damages, you know, prepare an attachment, you know, have that attachment, you know, be part of the lawyer. Minimize the work that the lawyer has to do in understanding the numbers associated with that and the facts. You can really cut your cost associated with that lawyer letter. And I think your expectation should be for, you know, a couple $1,000s. You know, the lawyer could get completely involved in the situation, read the contract, you know, read the key correspondence, understand the numbers, prepare the letter, and engage in follow-up conversations with the other side or the other side's lawyer to get you to a decision point. You know, whether it would be time to work out the challenge now or whether you need to move forward with some of your other rights associated with the collection activity. So lastly, Courtney, can we go to tip 5? Is to set a budget, right? Balance the cost of collection with the chances of recovery. You have to understand what a judgment actually is. So if you go to court and you prevail in court while in motion or trial, what you get is a judgment. And a judgment is a piece of paper that lives in the courthouse that says that company A owes company B money, or person A owes person B money. And that is half the battle. Taking that judgment and executing on that judgment to collect on assets and actually get paid can be just as expensive as the process of obtaining the judgment. So before you decide to spend a lot of money going after creditors, do some thinking, look for other creditors, dig into the assets of the business, and where possible, I always recommend a workout. It may not be the fair result for you, but it may be a good business decision. And you can work to replace debatable obligations with simple obligations. And what that means is, if you've got a contractor, a subcontractor who promised to perform work and they did some work, but it does not meet the specifications, well, now you've got a whole debate about whether the work that they did met the specifications, and experts get involved, and you have to try that case, and maybe it's tried to a jury. That is a really hard road. If you could reduce that obligation to a promise to pay from the subcontractor in a perfect world with a personal guarantee, and if that subcontractor fails to make the payment set forth in that payment plan, maybe there's a confessed judgment note. There are things that lawyers can help you do to really smooth the path to collection so that you can, make it more simple to collect. So those are some tips. If you find yourself in real challenge, you're going to need somebody like John. So John, if the workout conversations are not going well and you start to think about somebody owing you filing bankruptcy, or if your company, based on circumstances, has bankruptcy, I'll turn it over to you and help folks decide how to move forward.
Great, thanks, Jack. And Jack's correct. The goal today was to really walk through, the 3 steps that we may find ourselves in these days. I'll start out with the PPP loan, where a number of companies we may be working with or interact with get that relief, but that doesn't necessarily mean that all of those are going to get the relief that they needed, or that's going to provide the solution they needed. The next step is really, addressing the collections issue. That's, when the PPP loan may not be able to be used for paying down some of the debt of a company, or kind of some of the day-to-day costs that would involve paying you. So that's where the collections aspect comes in. And the bankruptcy overview here that I'll get into, really dovetails nicely with those, because when you're getting into the workout scenario, when you're dealing with collections, you don't have to necessarily delve too far into the bankruptcy realm, but understanding how the process works and the tools that a debtor has to help itself, those tools necessarily oftentimes can be difficult for the creditors involved and affect everything there. So the overview of my presentation is here. It's going to really be that the first couple of slides are going to focus on the warning signs and some basic concepts in bankruptcy that I think a lot of folks are probably at least high level familiar with. And then primarily we're going to delve into, after that, different concepts that come up a lot in bankruptcy, and the idea of how to get paid and protect yourself in bankruptcy. There's a lot of different tools in bankruptcy too. When I talk to clients, I oftentimes use the term bankruptcy dollars versus real dollars, and bankruptcy dollars tend to be very few pennies on the dollar. So we always try to focus on how to get you paid in real dollars and get you paid quickly, and try to figure out how that's going to happen and get you the relief that you need. And there are a lot of tools that are out there. So if we can move to the next slide, please. Jack did a great job focusing on, when we talk about collections, once we're into that scenario, that's obviously a warning sign that there's going to be some issues potentially with that project partner, either somebody up the chain or below the chain with you. My thoughts here are really, look, we can all focus on the macro and understand what's happening on the macro, but that's really just a cue to then focus more on micro issues, more project, or if you're dealing with a contractor on multiple projects, a contractor specific analysis to make sure that contract party is doing what it needs to do, and to look out, maybe be extra vigilant to look out for issues that may pop up with that contractor. I think on-site observations, their ability to meet their obligations, timeliness, as Jack said, if they're going quiet in discussions with them about different issues, that's always a telltale sign that there's an issue. Oftentimes they're trying to ignore the situation with you, or at least punt it down the road. So if we can move on to the next slide here. So very high level, I think most people are familiar with this. There's a lot of different types of bankruptcy, but the two main paths from a corporate standpoint are Chapter 7 and Chapter 11. Chapter 7, the company ceases to operate. Day-to-day control immediately goes to a bankruptcy trustee. All of the assets of the debtor are now in control of the Chapter 7 trustee. It's going to be a liquidation case. The business is going to cease. It will not move forward. There's some very, very minute exceptions to that, but they're really not ever worth talking about, because I think I've only seen it once or twice where some different contracts may be performed by a Chapter 7 trustee. But that's such a rarity. Chapter 11 is designed to be reorganization. The goal generally is for the business to continue. In recent times, that has really become, oftentimes, in some cases, the business does reorganize. Oftentimes, it becomes a structured sale of a going forward business to a new co that effectively is the same as the old co, but it allows it to be a very quick sale. So you might find a stalking horse bidder that comes in and says, I want to get into this trade or this construction contract type business, and they get into it by buying the business. You can also buy. Typically, it's not the business as a whole. It's just the majority of the assets. And what that does is the business can go ahead and move forward, and we're left dealing with what's going on, collecting money from the estate thereafter. Two quick notes about the Chapter 11 process as well. Typically, it is the goal is to be a reorganization. That doesn't prevent the case from turning south and turning into a Chapter 11 liquidation case. It doesn't necessarily have to be a Chapter 7. Obviously, filing Chapter 11 doesn't mean you're going to be successful in it, but it's much better if you're going to file 11 to be successful in reorganizing. There's also been some recent legislation, and today's goal is really to focus on the creditor side of this, but just to make everybody aware, because it will affect the creditors as well. About a year ago, there was a Small Business Chapter 11 Act that was voted on by Congress, and it went into effect, I believe it was earlier this year, if not the tail end of last year. And that provided a much more concise and streamlined process for what it was deemed as a small business to get in, try to reorganize with a plan, and then get out of bankruptcy. And if the plan doesn't work, there's a liquidation. That's a tightened time frame. That's about that plan, and the voting is something that would have to happen in between about 3 and 6 months. And the small business under that act, at least when it was initially passed, was about $2.5 million. The goal is, if you're truly a small business, you can get in. There's some extra tools in that legislation. And then if you're going to be able to emerge out of bankruptcy, it's a quick process to avoid what can oftentimes be a somewhat costly process if you're a debtor, and the cost oftentimes is reflected, goes up equally with the time that you're in bankruptcy. That has actually changed for about a year under the CARES Act. So the CARES Act, of course, is what put in some of the legislation that we're all familiar with now. But importantly, there was a provision in there that increased the definition of a small debtor. Beforehand, it had been around $2.5 million. So if you're a small business that owns real property or has significant assets on site, you may quickly get to that number. But the CARES Act increased that number, I believe, to about $7.5 million. That encompasses a much broader grouping of potential debtors. So if you're a creditor, that's important to know because that's definitely an option for smaller businesses that may have said, I don't want to go into Chapter 11. It's expensive. Maybe it's a process I can go into to reorganize now that allows kind of medium-sized, mid-sized businesses to go in, and it's a quick and from their perspective, cost-effective method of filing Chapter 11 and getting out of it. So if we can go to the next slide here. Okay, we all know what the automatic stay is, I think, if we've ever dealt with bankruptcy before. General rule here, the number of different exceptions, but basically if there's an issue with the person who owes, if somebody owes you money and they file bankruptcy, your collection action has to stop. There are different ways to collect money from the debtor, not just filing a proof of claim, but effectively that lawsuit you may have to collect, that process you're taking to go after them, the threatening letters you're sending, they should stop, and you should deal with it in the bankruptcy court. The idea of bankruptcy is to say, look, we're all here, and we want to deal with it in one form, and that's one of the major tools for a debtor is the automatic stay. It also stops the non-debtor from terminating a contract. So even if you've got a contract that has a breach provision in it, and the breach continues post-bankruptcy, at least for a time being, you can't just say, look, the contract's terminated. You have to file a motion for relief from the automatic stay and demonstrate that the contract should be terminated, and there's some rights the debtor has. And importantly, and this will be a big concept, it's a very big concept in construction, it's limited to the debtor's property. So the debtor has property on its, if it owns real property and there's a third party's property on site, or goods have been delivered but title hasn't changed, the automatic stay only relates to the debtor's property. So that's an important concept, particularly in the construction industry. You can move on to the next slide here. Okay, so one of the major issues is how do we deal with construction contracts in bankruptcy? All of these contracts are going to be known in the bankruptcy world as executory contracts. That's a fancy way of saying you both have obligations under the contract to the other. And these are, I'll just walk through these different concepts here. I'll actually start from the bottom up. In a lot of contracts, and frankly, I'd say almost every contract I see, and I feel like there's some sort of, termination on bankruptcy, on the filing of bankruptcy, or breach by the filing of bankruptcy. Those clauses are invalid. The law is very clear. They mean nothing as it relates to the debtor. Now that's an important concept here. Some contracts, of course, there may be multiple entities involved that are related. There may also be guarantors. If a guarantor files bankruptcy, but the main contract party does not, that could be a breach under the contract and allow you to execute some rights that you have that wouldn't prevent you from going after the other party, the main party here. So that's an important concept, but as it relates to the specific debtor, that clause is meaningless. You'll find also anti-assignment clauses. These are very popular in leases and construction contracts, and they're important. You don't want the counterparty to your contract to randomly assign their rights under the contract's obligations to a third party that you haven't vetted, so you want to make sure that's not allowed. As a general rule, bankruptcy invalidates those assignment provisions. There are a couple of issues here. The first is if you have a contract with the federal government, if they're the owner of the property, there are other federal acts, legislation that will prevent you from assigning the contract. So even though the bankruptcy code says you can, the anti-assignment provision is invalid, the other federal acts out there can prevent that from happening as well. The other issue is it's not a carte blanche right of the counterparty of the contract, if they're the debtor, to be able to assign the contract. You have rights too. You're on the other side of that contract. The question is, what do you do? Even though they have the theoretical ability to do that, you have the right to make sure that whoever they're assigning it to can then perform under the contract, right? If they're a subcontractor that does certain work, and they filed for bankruptcy and want to assign it to a third party that doesn't do anything in that field, you have a right to inspect whether or not they can actually perform under the contract. If they can't perform under the contract, you have rights to object to that attempt to assign that contract. And that's important because the goal is if the contract is assigned, you'll have to continue to performing as you always will. And so will they. But if it's assigned to somebody who can't perform, it just kicks the can down the road for you and doesn't help you out. So that takes us back into this bigger issue of contract assumption, rejection, and assignment. These are major tools that a debtor has. A contract can have value. If you are making a lot of money on a contract and can assign it, you can oftentimes sell that contract to a third party if you're the debtor. So if you're the counterparty in our position here, the creditor, the question is, what does that mean? And you want to be vigilant and aware of this. A lot of these actions, they all require motions in bankruptcy. A lot of these actions are thought of by the debtor before they file, and they'll file motions at the beginning of the case that have a significant effect on a number of different creditors, including potentially one of us, it may be the counterparty here. So what does assumption mean? That's typically a good sign. If a debtor wants to assume a contract, that means the contract that they think they can perform. And as the creditor on the other side of that contract, you generally like this because if they assume a contract, they have to fully perform under the contract. So if they owe you money before that assumption is effective, they have to pay you in full. There can be negotiations. Sometimes they may try to pay you less, but your rights under the bankruptcy code are pay me 100 cents on the dollar, become current. They would also have to demonstrate an ability to continue to perform. If you're going to assign a contract, it's going to be assumed first and then assigned. Again, the same issue is there. Even if the contract goes to a third party, you better be getting paid. You better know, and they better be able to demonstrate that whoever's getting that contract can definitely perform under the contract. Let's think about rejection. If you're in Chapter 7, rejection will occur by way of the bankruptcy code, but you may want to get out of the contract because it's Chapter 7, it's a liquidation. You can get out quicker by filing a motion to reject. Debtors often file motions to reject as well. It's a negative contract for them. In the news, you read about a lot of retail companies filing. What they oftentimes do is they use the ability to reject an expensive non-money making lease and get out from that. What does it mean for you to be the counterparty? That's a breach under the contract, and you will be paid those breach dollars, in bankruptcy dollars. It pushes those dollars and considers them all pre-bankruptcy dollars. At that point, the contract is effectively terminated, and you can move on and do what you need to do to make sure any work gets performed as well. So that can be significant. One of the issues too that a lot of creditors find is somebody files bankruptcy. Do I have to continue to perform my work in bankruptcy? And the answer is yes, you do. You need to continue to perform and meet your obligations under bankruptcy as well, and particularly in this Chapter 11 context. One key concept here, though, is we don't always know if there's going to be an assumption or rejection immediately in the case. That's something that you can explore with the debtor or debtor's counsel. But if it's unclear or you're getting the feeling that they are going to reject or not be able to perform, you can quickly, you can file a very simple motion requiring or asking the debtor to assume or reject your contract to force the issue. If you want them to do that, you want to have some evidence there that there's a question of performance. But while bankruptcy gives the debtor a lot of rights, that doesn't mean you're left without your own rights. So you can force this issue if it makes sense. And a lot of times it does, because your time, your dollars, your effort is tied up in a project or under a contract. You want to know the ultimate result. You may not know it immediately in these cases, but the debtor can wait a fairly long time before deciding. And if there's a reason for you to know early, you can take some proactive steps to get that answer for you sooner rather than later. Okay, the next slide here. All right, one of the next big issues in getting paid, we've talked about a lot of times the service contracts, what do you do in those cases to make sure you get paid. If you're a supplier or a vendor of goods, there's a lot of different steps you can take. Unfortunately for labor, this doesn't necessarily apply, but if you're providing both, they do. This first concept will apply actually to both. This idea of set off and recruitment. These are state law rights under contract. The idea here being that if you have mutual debts, they should offset each other, right? It only makes sense. If I owe you $100 and you owe me 90, I should only owe you 10. The great thing here is this is a great way to get paid if you're a creditor. If you have set-off rights or recoupment rights, you can, in the bankruptcy case, file a motion for relief from the automatic stay and set off the debts from each other. If you owe the debtor money, as opposed to having to pay them and maybe not getting paid back by them, you can get paid theoretically your $90 in that example I provided by asserting your set-off rights, and then at most you only owe them 10. That's beneficial because if you were to have to pay them the $100, you may risk not ever getting paid the 90, so then you're out 100. Whereas if you assert your set-off or recoupment rights here, you can reduce, then effectively get paid in real dollars, which is bankruptcy dollars for a large portion of what you're owed. Those concepts are a little bit different. The idea between set-off and recoupment is set-off is, I believe it's money owed under the same contract. Recoupment is you have multiple contracts between the two parties, but the concepts here on how to get that done are effectively the same. We don't need to get into the technical aspect there. Like reclamation, again, it's another state law concept that is affected a little bit by bankruptcy. And again, the concept here is, look, you have state law rights and remedies. A lot of what Jack talked about, they don't just stop because somebody files bankruptcy. The code incorporates a lot of these concepts and allows you to still enforce these rights. And reclamation is important. If you're a vendor and you've delivered goods to a project site, but they haven't been used, there's typically about a 20-day period, or depending on the state law, to assert those reclamation rights and potentially get those back. Reclamation is a concept where if you've delivered something to an entity that's insolvent, you can assert those rights and try to get the goods back. There's some proceedings you have to go through in the bankruptcy case, but they're really not complex. They're very straightforward. Get a letter, file a quick motion, try to get it done. Again, that's great for you because as opposed to being out the goods and not getting paid, it allows you to get those goods back. So the next is what's known as a 503b9 claim. Again, it's not very complex once you get into it. When we talk about bankruptcy dollars, there's a waterfall analysis as to who gets paid first. If you're not a secured creditor and don't get paid off of an asset you're secured from, the top dog is known as administrative expense creditor. It's a creditor that provides goods, typically post-petition, to a debtor. Unless the debtor has major issues, you get paid in 100% real dollars. The idea of a 503b9 claim is if you provided something, if you're considered a critical vendor, you provided goods in the immediate period pre-bankruptcy, you're deemed to also be able to assert that administrative expense claim. And that's really critical because for that 20-day period you have here, you should be getting paid 100 cent dollars. You just need to assert that claim, and it's a way to really jump out in front of other creditors to make sure you get paid. When a pot's limited, making sure you're at the top of that waterfall any way that you can is absolutely critical. The key to all of these is not any of them are overwhelmingly complex. Most of these have time limits and you need to assert them. But again, to assert them, it's a fairly straightforward, fairly standard process. It's just something you need to be aware of and rights that you need to assert. The debtor is not going to help you out, right? The debtor's in there to get out of bankruptcy, to reorganize. The debtor's not going to help you out. Okay, we can move to the next slide. Okay, this slide's on mechanics liens, and the next one will be on payment bonds. They tend to be two sides of the same coin. The key concept with mechanics liens are this: if you're asserting your creditor rights pre-bankruptcy, you're not prevented from perfecting your mechanics lien post-bankruptcy. So if you've met the technical requirements pre-bankruptcy, you can still perfect post-bankruptcy, and that's great. Again, the concept here is making sure you get paid as much money as possible. Having a lien on an asset is a great way to get paid more. If nothing else, you've got really great negotiating leverage here. Again, Virginia's very technical. You have great rights in the mechanics lien statute. You still need to meet those technical requirements. and the bankruptcy doesn't extend any deadline. So if you have to perfect and it's 3 days after they file bankruptcy, go ahead and perfect, get it done, and be aware of that deadline passing. We can move to the next slide, please. Okay, payment bonds.
Hey, John, I was just looking at the time too. I think we're a couple minutes over. You want to wrap up and maybe we'll just do one hypo?
Yeah, I'll wrap up very quickly here. Apologize for going over time. The key here is, again, we talk about getting paid. Payment bonds, unless there's an exception, are not going to be property of the estate. And we talked about it earlier. That means they're not subject to the automatic stay. That means you should also be able to get paid in full. So make sure you're asserting those rights. If you have obligations on the bonds, don't let the bankruptcy process worry you. Do what you need to do, assert your rights, and try to get paid in full. Okay, we can go forward. These are mainly a summary of what I just talked about, so we can skip that and go to a hypo if you want to, Jack.
Yeah, thanks, John. So I think Courtney and Sheila, let's just take 2 more minutes and circle back to Holly maybe for just one hypo. And then I didn't see any questions, but certainly we could stay on for another minute or 2 and cover any questions. So the hypo. One on the slide there, Holly, I'm the CFO of a general contractor and we got a PPP loan. I open a mail and it's a letter from the government telling me that my loan is under review. What do I need to do in that exact moment to start the process of preparing a response to that letter?
So for the purposes of this hypothetical, let's assume that when you say the letter from the government that it is from the SBA. And they're conducting a review, probably in connection with your forgiveness request. So in that regard, congratulations, you've been on this webinar and you know what materials to gather. You'll have the slide where we enumerate them, and you'll be prepared to walk through the balance and the background for your certifications. You want to make sure that each of your certifications has backup. It's advisable that you review it with persons knowledgeable for the basis for that certification so you can show it's in good faith, and consult with counsel just to make sure your ducks in a row. If, on the other hand, that letter is from an inspector general and it is not typical for them to start a communication with just a letter saying, hey, can we see some information? Seems casual, but you're under investigation by the IG. Similarly, it could be a letter from the DOJ introducing this investigation process. In that case, you need to immediately go to counsel, whether it be your in-house counsel or outside counsel. But at that point, there is a higher exposure of civil and criminal liability, and you need to make sure that you know what the government is looking at and what your next steps should be, which will be highly individualized.
Thanks, Holly. So, Courtney, I want to be respectful of everybody's time. So I'll turn it back to you and, any questions or wrap up. Thank you.
Yeah, no, we appreciate it. You all have been great over the last 3 weeks. And I think, cumulatively, we've had over 100 people that have watched these webinars and a lot of good questions. So AGC will follow up by sending out your all's contact information, also the slides and the recording of the webinars. So we hope to continue to keep the dialogue going. And then also just appreciate the continued conversation, because I know several times you all mentioned, this could change by the time that this slide is published. So we understand, that things are constantly changing, and we appreciate you guys being accessible for that kind of day in and day out. So thank you all so much. And if anybody on the webinar has additional questions, you can send those to AGC or send them. Oh, look, somebody just popped in with a question. Is there a time limit on mechanics lien claims?
John, you want to handle that for Virginia? That short answer is absolutely, and it's highly technical, and you cannot miss the deadline.
Yeah, and I offhand I couldn't tell you. There's a couple different deadlines to meet. One is the notice, and then the additional information you provide. So there's multiple different steps there, but but definitely deadlines. If we're talking on the bankruptcy side, the same deadlines are there. But Virginia's in Virginia, you get fairly significant rights when you file a mechanics lien. In some states, you kind of fall in line and don't necessarily become kind of a super creditor. And in Virginia, the mechanics lien is very powerful and can prime a lot of other creditors out there that have liens on that property. So in Virginia, it's very tactical, both in what you describe your claim as being, but as well as a timeline to file that claim.
Perfect, thank you. With that being said, if for all of our attendees, if there are topics that are not covered or that you would like to dive in more detail on and see webinars on, please let us know here at the AGCVA, because we want to continue to produce relevant webinars for our members. So just want to say thanks again to all of our panelists. We really appreciate the time and the energy, and we will talk to you guys soon.
Thanks all.
Thank you.
Thank you.